Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Welcome to the Empowering Plans Podcast today. My name is Cindy Merrell, and I'm here with attorney Andrew Silverio. Hi, Andrew.
Hello. Hey, Cindy. How you doing?
I'm good. So I am in the Louisville office, and Andrew is up north in the Massachusetts office. No, you are now in Cleveland. You were in the Massachusetts office. Now
Yep.
You're in the great state of Ohio. Okay.
Yeah, I started back when we had our Braintree office, and now I'm out in glamorous Ohio. And yeah, I actually started doing subro exclusively, and it's been years since I was in that world. So I know that's what we've got on the agenda today, and it'll be good to jump back into it and kind of refresh myself and hopefully learn some things too.
And today we are going to talk about a case that is hot off the press, and it was decided on January 29th. So it's a brand new case. And what I'm excited about this case is it helps clarify some of the options a plan may have when it is seeking to enforce the terms of a plan document through subrogation. And one of these things that occurs when we have a plan member who decides that they don't want to observe their obligation, reimburse the plan at the time of a bodily injury settlement, is we have the option to go enforce an equitable lien. So I want to first talk about equitable liens and delve into the facts of a case. But before we get there, I want to get us to the roadmap of where we are in a case. So typically, when an at-fault party causes a member an injury and pays benefits, we are trying to confirm which payor is the proper payor of the member's medical expenses. Once we determine that the plan has paid benefits and that there is an at-fault party and there is a recovery to be made, we are seeking reimbursement, typically instead of direct subrogation, because we are pursuing reimbursement from the member at the time of settlement. What happens sometimes, though, is plan members don't pay their plan and they don't observe their duties under the plan. And at that point, the plan has to determine how it would like to enforce the terms of that plan. So we've gotten all the way through that point. What's happened in this case is called Verizon Sickness and Accident Disability Benefit Plan versus Rogers, and it's out of the United States District Court in Rhode Island. And what happened in the case is a plan member received disability benefits through the Verizon Disability Benefit Plan, and the member received a $100,000 recovery. And for some reason, the member's attorney determined that they were not going to pay the disability benefit plan. Instead, they were only going to pay the health plan portion of it and not the disability benefit reimbursement. And the attorney took his fee, dispersed the rest of the funds to the member. They did pay the medical portion, but they did not pay the disability lien. And for whatever reason, Verizon could not locate their employee after she got the settlement funds. And they couldn't go after the member because she couldn't locate her. So the only remaining party with settlement funds was the member's attorney. And that attorney took a fee of approximately a little over $30,000. And Verizon wanted to enforce the plan's right of recovery, right of reimbursement, by going after the funds that the member's attorney had. So what are we looking at right now? The first thing that jumps out at me is we're talking about an equitable lien. So an equitable lien is unlike a contractual or a legal lien. And in this case, the equitable lien is, instead of having a contract where I promise Andrew I'm going to pay him a loan, where I'm going to pay him back, I don't know, $10, and I don't pay him back, he can enforce, that's a contractual right of recovery. An equitable lien is the member has accepted the benefits of the health plan. The only way we can enforce the ERISA action is through an equitable lien as opposed to that legal lien. So it's not just like it's your contract. Go ahead,
and that's a tricky distinction for sure. And I'm glad both of the examples you just gave were a loan, because the first example I always give of a legal remedy in this context is a debt. So a personal debt which is just, I owe Cindy $10. It doesn't really matter why. It's a legal right, a legal remedy, and she could recover that $10 from my general assets, whether that's, in my wallet because I haven't bought lunch yet today, or my bank account, or my joint savings account that I have with my wife. It's just a general debt. Whereas an equitable remedy, which is what an ERISA plan has, is a much more specific interest in a specific identifiable resource, in this case, a settlement fund. So back when I was working cases back in the day, the big kind of just earthquake event after a recovery is the funds being dispersed, right? I remember it's a huge deal. You have to stay on top of the attorney because once they disperse the funds, pay them out to the plaintiff, you're out of luck. You can't really do anything because you no longer have that identifiable settlement fund and you don't have a personal debt interest against the participant. If you can no longer identify those specific funds that they recovered, you're out of luck because the thing of value, the pool of funds that you had an equitable interest in, is gone. So your equitable interest is gone.
For example, they go spend $60,000 on, I don't know, lottery tickets. You're out of luck if you're the plan. There is no identifiable asset anymore in which the plan could seek a reimbursement. That's a good point, and I appreciate you bringing that up. So right now we have the equitable lien, and the member is gone. They could not locate the member. They decided to go after the member's attorney, and he had put his funds in the general operating account of the law firm. And what happens at that point is the plan has to then, through discovery and litigation and forensic accounting, they have to identify where those funds went and how much of that in that general operating account of that attorney, what that level, let's say when he put the funds in, that there was $50,000. Remember, there was a $30,000 attorney fee on that. Let's say he had $20,000 sitting in his general operating account. There is a rule that the plan calls the lowest intermediate balance. So think about this when Andrew was talking about his joint checking account with his wife. If they're co-mingling those funds, the lowest intermediate balance from the time that they put the funds into the account to the time that the plan is seeking that, typically it's when they file litigation, whatever that lowest balance is going to be the maximum amount the plan can recover. So I always think about this like a bathtub. Think about if you make a red line on a bathtub, you fill up the bathtub and you empty some water and it goes below the line, and then you put in more water and it goes above the line, and then it goes back below that red line. If it goes back below the red line at any point, that's the maximum amount the plan can recover because that's the lowest balance that account had. So once they've commingled those funds, and it went below that red line, we can only seek up to the amount that it went as long as it's below the red line. That's called the lowest intermediate rule. And what they were determining is whose burden it is to prove that the funds have been dissipated, and then the lowest intermediate balance. And this court determined that it was going to be the plan's burden to prove that the funds have been dissipated. And that's important because that's really not been clarified before. If they elected to pursue through this mechanism of enforcement, it is the plan's burden to prove this. And forensic accounting is one of the ways the plan can do that through discovery in litigation. So that, I think, is very important. What I took away from this, the most important thing for me that I found to be interesting, is that they went after the member's attorney. I think that was a good move on this case because although it didn't turn out to be in Verizon's favor, because in this case, they determined that the lowest intermediate balance, that the funds had been dissipated and the plan could not obtain that recovery. What I found most interesting is now we have a precedent that we can go after the members' attorneys in this situation. That wasn't confirmed or cleared to me before this case. Andrew, what were your thoughts on this?
Yeah, it's interesting. So in a way, you're sort of going after the attorney's general assets in that, his or her portion of that settlement fund was commingled into that general operational account, right? So the funds you're going after are literally within their general assets. You're still not talking about a debt. You're still talking about an equitable remedy. But the court really laid out the procedure for showing that that pool of general assets still contains the funds from that settlement, with the whole process of the forensic accounting and showing the lowest balance that the account had held. I thought there was an interesting assumption built into that test that, funds that had been expended out of that account were not themselves the settlement funds, right? That test is assuming that the settlement fund, when put into that general account, was sort of set aside as the last possible thing, the last pool of funds that you're going to spend on any expenses, right? Who's to say that, if you put $30,000 into a $50,000 account and then spend $40,000, who's to say that we shielded that $30,000 from our expenses versus paying it first, right? That's kind of an important assumption that the court didn't touch on, because I don't see how you could really reconcile that. It's going to be, one party's word against the other. And of course, they're each going to say, yeah, first in, first out. This is the most recent funds. I spent it on operating expenses. It's gone. These other assets in the account are older. And the plaintiff is going to say, no, it's the opposite. So it's interesting they didn't touch on that. I can see why. But yeah, we have a roadmap basically now for even when a plaintiff's portion of the settlement is paid out, going after the attorney. I don't see any reason you couldn't use the same approach against a plaintiff as far as their share of the settlement funds. If they just dumped it into their own, general bank account, you could do the exact same thing. So it gives plans sort of a playbook in this situation where previously they might have just thrown up their hands and said, oh, well, it looks like we missed out.
Exactly. And one of the things I want to remember is that these situations, they are not as often as you might think, because there are other mechanisms in which the plan can enforce if they disperse the settlement funds. One of the ones we've talked about previously was an offset of future benefits and things like that. This is just a mechanism in which the plan can self-help to enforce the terms of the plan document. This would be the very expensive option. And this is forensic accounting in itself can easily exceed, $20, $30, even more than that, $1,000 in expenses. But sometimes if there are enough settlement funds and the plan has a significant amount of benefits advanced, this is definitely an option to consider when we're looking at how to recover when the funds have been dispersed. Well, I think that's all I have to say on this one. And Andrew, I thank you for your input on this. And that's another episode of Empowering Plans with the FIA Group.